Hello and a warm welcome to Well This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notification for new videos. My name is Sheetal Joon, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. This week, the Supreme Court Constitution Bench continued the historic hearing in the matter of marriage equality. Appearing for Centre, Solicitor General Tushar Mehta told the bench that it is dealing with a very complex subject with a profound social impact, and the real question is who decides what constitutes marriage and between whom. He added that there would be ramification on several other statutes that would necessitate a debate in society that in various state legislature. On the other hand, the petitioners urged the Supreme Court to recognize their right to marry, saying that there cannot be a situation where the court will say that it will give nothing as it can't give everything. Not granting legal sanction to same-sex marriage would amount to clear discrimination on the basis of sexual orientation of a person, and this may lead to gay brain drain, where such person will be forced to go to other countries for enjoying the fruits of marriage and other consequential benefits. Senior advocate Saurabh Kripal, who himself identifies as a gay, argued. The top court has asked the ruling government at the centre to give a response on social benefits that can be given to same-sex couples even without the legal recognition of their marital status. The court asked Solicitor General Tushar Mehta to see if there can be separate legislation which would protect the right of a same-sex couple. Solicitor General expressed his acknowledgement that concerns such as having a joint bank account, nomination, insurance are all human concerns, and there can be deliberations to find a solution thereto. Solicitor General indicated that he can attempt to undertake this exercise since the suggestion has come from the bench itself. CJI Chandrachud has remarked that the government must recognize and secure cohabited relationships. Notably, observing that even as irretrievable breakdown of marriage is not a ground for divorce, under the Hindu Marriage Act and law has not been amended to incorporate the provision despite the Apex Court suggestion and recommendation of the Law Commission, such marriages inflict cruelty on both husband and wife and can be dissolved under the ground of cruelty if parties are not agreeable to divorce. A bench of Justice Sudhanshu Dhulia and Justice J.B. Pardiwala said continuation of such broken relationships causes cruelty on both sides and the court can grant divorce on the ground of cruelty under Section 13(1)(ia) of the Act. The court granted divorce to a couple who has been living separately for the last 25 years. It allowed the petition of the husband against whom his wife, who was opposing the divorce, filed numerous complaints. The husband was arrested but finally acquitted. Law Commission in its 71st report said that the irretrievable breakdown of marriage should be incorporated as another ground for granting divorce, and the same was reiterated by the Commission in its 217th report. The Apex Court also made a strong recommendation to the centre to consider adding irretrievable breakdown of a marriage as a ground for divorce under the Hindu Marriage Act. The 5-judge Constitution Bench of Supreme Court has ruled on a significant point of law as to whether arbitration clause in an unstamped instrument exigible to stamp duty can be invoked or not. The bench of Justice K.M. Joseph, Justice Ajay Rastogi, Justice Aniruddha Bose, Justice Hrishikesh Roy and Justice C.T. Ravi Kumar with a 3-2 majority has ruled that the invoking of the same is not valid in law. An instrument which is exigible to stamp duty may contain an arbitration clause, and which is not stamped cannot be said to be contract enforceable in law within the meaning of Section 2H of the Contract Act and is not enforceable under Section 2G of the Contract Act. The majority view read: Justice K.M. Joseph, Justice Aniruddha Bose and Justice C.T. Ravi Kumar wrote the majority view, while Justice Ajay Rastogi and Justice Hrishikesh Roy dissented, opining that unstamped arbitration agreements are valid at the pre-referral stage. It was their observation that non-stamping or insufficient stamping of the substantive instrument would not render the arbitration agreement unenforceable, as stamp deficiency is a curable defect and the same would not be rendered the arbitration agreement void. The Supreme Court has directed all the states' appropriate authorities before whom the mercy petitions are to be filed that such mercy petitions be decided at the earliest, so that the benefits of delay in not deciding the mercy petitions is not accrued to the accused. The division bench of Justice M.R. Shah and Justice C.T. Ravi Kumar observed that along with the gravity of the offence, the inordinate delay in disposal of the mercy petition is also relevant while commuting the death sentence to life imprisonment. The ultimate objective of death sentence would be defeated if even after the final conclusion came up to this court, even thereafter there is an inordinate delay in not deciding on the mercy petition. Therefore, the state government or the related authorities must make every effort to ensure that the mercy petitions are decided and disposed of as soon as possible, so that even the accused can learn his fate and even justice is served to the victim. The Supreme Court has held that the grant of bail on the ground of undue delay in the trial cannot be said to be referred by Section 37 of the Act, given the imperative of Section 436A, which is applicable to the offences under the NDPS Act too. The Division Judge Bench of Justice S. Ravindra Bhatt and Justice Dipankar Datta observed that the courts must be aware of twin conditions, that there are sufficient grounds of believing that the accused is not guilty of such offence and that he is not likely to commit another crime while out on bail. The additional requirement that the court must be convinced that the accused is not guilty must be interpreted reasonably given the mandate of the general law on bails, while classifies offences based on their gravity and instructs that certain serious crimes must be dealt with differently when considering bail applications. The court has generally upheld such conditions on the ground that the liberty of such citizens have to, in case when accused of the offences enacted under special laws, be balanced against the public interest. It was noted that a plain and ordinary interpretation of this condition under Section 37 would effectively forbid the issuance of bail completely, leading to punitive incarnation as well as unlawful preventive detention. As a result, only in cases where the court is fairly convinced that the accused is not guilty after taking a prima facie look at the evidence in record and such specific criteria as those enacted under Section 37 be taken into account within the boundaries of the Constitution. It was furthermore noted that given the requirements of Section 436A, which is applicable to offences under the NDPS Act as well, it cannot be stated that Section 37 of the Act restricts the granting of bail on the ground of unjustified delay in the trial. The court added that it is crucial to consider the fact that while laws are strict, requirements for the bail may be required for the benefit of the public. The injustice caused to the individual if trials are not completed on time is unfathomable. The Supreme Court has expounded that the principles of Audi, alteram, partem cannot be excluded from the Reserve Bank of India frauds classification and reporting by commercial banks and selected FIs Direction 2016. The Division Bench of Chief Justice D.Y. Chandrachud and Justice Hema Kohli observed that as per the principle of natural justice, the borrower must be served notice, given the opportunity of hearing and allowed representation before the account is classified as fraud. The bench further noted that the principles of natural justice are substantive obligation and have to be followed by the decision-making authorities, and clarified that at the stage of reporting a criminal offence, no principles of justice are applicable. It was further pointed out that classification of a borrower's account as fraud does not only lead to reporting of criminal companies, but there are also penal consequences attached to it. The forming of opinion under the Master Directions on fraud is administrative in nature. The law is settled on the point that the principles of natural justice do apply to the administrative action, apart from judicial and quasi-judicial functions. Further, it is mandatory to provide the opportunity of a hearing. The Apex Court opined that in cases where civil consequences affect citizens adversely, the order of proceeding should be in consonance with the principles of natural justice. The court noted that even though action taken by banks in lieu of public interest, the same does not major civil ramification for the borrowers. The consequences in lieu of penalty imposed are penal in nature. Next we have Delhi High Court. The Delhi High Court has set aside the Delhi University's decision to debar NSUI, Congress's student wing secretary, for alleged involvement in screening of a recent controversial BBC documentary on Prime Minister Narendra Modi, India, the Modi Question, investigating role of the then CM in infamous 2002 Gujarat riots. Lokesh Chuj, a PhD research scholar at the Department of Anthropology at Delhi University, was debarred from appearing in any university college department examination for a period of 1 year on the premises that he masterminded the screening, which amounted to indiscipline on his part. The single judge bench of Justice Pushpendra Kumar Kaurav has now quashed the decision for violation of principle of natural justice and restored Chuj's admission to the varsity. The Delhi High Court has granted 1 month's time to the Delhi government authorities to decide a representation to legally recognize the transgender community as the third gender in bus ticket issued by the DTC. In case of non-compliance, the Managing Director of the Delhi Transport Corporation shall remain present before it on August 18, the court order. The court order came on contempt petition filed for willful non-compliance of an October 2022 order of a division bench which had granted 4 months to the authorities to take a view on the representation. Observing that there is no requirement in law to impede the victim to any criminal proceedings, whether instituted by the state or by the accused, the Delhi High Court has directed that the registry must carefully scrutinize all filings related to sexual offences to ensure that anonymity and confidentiality of the prosecutrix, victim or survivor is strictly maintained. The single judge bench of Justice Anup Jairam Bhambani stressed that in order to maintain confidentiality, name, parentage, address, social media credentials and photographs of the prosecutrix, victim or survivor must not be disclosed in the filing made in the court, including in the memo of parties. The Delhi High Court has decided to pursue the contempt case against RSS Gurumurthy, the editor of Chennai-based Tamil News magazine, after he refused to file another affidavit tendering an unconditional apology for his tweet against Justice S. Muralidhar. Guruswamy's counsel said that the journalist has already tendered his apology in relation to the tweets and there is no necessity for him to file another affidavit conveying an unconditional apology in the clear terms. The division bench of Justice Siddharth Mridul and Justice Talwant Singh noted that the 2018 affidavit did not contain any apology, and if the journalist files an affidavit with two-line apology, the court can put quietus on the issue. It said that earlier affidavit was merely a reply on the merits of the matter. Remarking that there is no All India Judicial Services for judges, the Delhi High Court has ruled that judicial services rendered in past in a different state cannot be counted for deciding seniority in the current service in another state or union territory. The division bench of Justice Manmohan Singh and Justice Saurabh Banerjee, in the view, dismissed a petition filed by a civil judge who voluntarily resigned from the Haryana Civil Services in 2018 and joined Delhi Judicial Services by way of clearing the requisite examination. The court noted that there is no All India Judicial Service for judicial officers and that HCS and DJS are distinct judicial services of two different states governed by different services rules and controlled by different high courts. The constitutional scheme as reflected in Articles 233 and 235 is that each high court of the state has a control over the certain courts under its jurisdiction. Consequently, this differentiation is constitutionally sanctioned itself. It observed that the case of the petitioner is neither of absorption or compassionate appointment, nor of deputation, nor of transfer, but that of simpliciter resignation. And since DJS and HCS are not departments of an All India Judicial Service, the petitioner had to complete the prescribed eligibility criteria of service in the federal grade, that is DJS. Noting that the condition precedence for the participating in the LDCE examination is the fulfillment of 10 years of qualifying service, the court asserted that according to Rule 2E of the DGS rule, service means the Delhi Judicial Service, as there is no provision for interchangeability or counting of previous service in any other service in the DGS rules, the court cannot extend such benefit beyond the prescribed purview there. Now let's have an overview of other high courts. The Bombay High Court has ruled that crane used in private premises of a coal mine falls within the meaning of motor vehicle under the section 228 of the Motor Vehicles Act 1988. The single judge bench of Justice Urmila Joshi Phalke, in the view, upheld the compensation granted by the MACT to the family of a Western Qualified Limited employee who died in a collision with a crane during the work. It referred to V.M. The Bombay High Court has ruled that crane used in private premises of a coal mine falls within the meaning of motor vehicle under section 228 of the Motor Vehicle Act 1988. The single judge bench of Justice Urmila Joshi Phalke, in this view, upheld the compensation granted by the MACT to the family of a Western Qualified Limited employee who died in a collision with the crane during work. It referred to V.M. Salgaonkar and Bros versus Board of Trust of Port of Morgaon and another, and observed that it has been held that the machinery is adapted for use designed for use in an enclosed place as is distinct from a road. In fact, it is clearly mentioned that machinery which is designed for all of the road use, section 228 motor vehicle or vehicle means any machinery propelled vehicle adapted for the use upon roads, whether the power of propulsion is transmitted thereto an external or internal source, and includes a chassis to which a body has been attached under trailer, but does not include a vehicle running upon fixed rails or vehicles or a separate type or used in any factory or in any enclosed premises, or vehicle having less than 4 vehicles fitted with engine capacity not excluding 20, and thus motor vehicle as per its definition means any machinery propelled vehicle adapted for use upon roads, including a chassis to which a body has not been attached, whether the chassis is a 2-wheeler or 3-wheeler, scooter or motor vehicle, motorcycle, the court observed, citing both Abraham versus the state of Kerala and another, wherein it was held that the mere fact that the excavators are used in an enclosed area and the road rollers are used only for making roads and not as vehicles, that this does not render them to be different kind of vehicle, and since the excavators and road rollers are motor vehicles for the purpose of MV Act, the court observed. The Calcutta High Court has held that Section 167(5) of the Criminal Procedure Code unequivocally states that magistrate can stop the investigation on contingency that the investigation officer has failed to satisfy the magistrate that for special reasons and in the interest of justice, the continuation of the investigation beyond the period of 6 months is necessary. There cannot be any automatic order without anything else on expiry of a period of 6 months from the date of arrest. The single judgment of Justice Ishwarato Majumdar observed that Section 167(5) of the Code of Criminal Procedure clearly indicates that the magistrate has the right to stop an inquiry if the investigating officer is unable to persuade the magistrate that further investigation beyond the first 6-month period is required for specific reasons and in the interest of justice. When passing a period of 6 months from the date of the arrest, there cannot be any automatic order without anything else. The Odisha High Court has observed that the power to hear an appeal under Section 373 of the Criminal Procedure Code includes the power to grant all consequential relief, including the power to stay the operation of the impugned order till disposal of the appeal. The single judgment of Justice Shashikanta Mishra clarified that the appellate court has the power to make any consequential or incident order that may be just or proper, which includes the power to stay the operation or the order impugned in the appeal, and the court pointed out that the below court has erroneously held that the power under Section 386 CRPC is only meant for appeal under Section 377 or 378 CRPC. The Himachal Pradesh High Court, while considering the writ petition, noted that the contract service of an employee before the regularization of his service have to be considered while calculating the time period for employment for the purpose of pension, especially when the initial contractual employee is not for a short or limited period. It noted that the qualifying service of a government servant commences from the date he takes charge of the post to which he has first been appointed, either substantively or in an officiating or temporary capacity, and then it was concluded that in the current matter, the contract service of the petitioner is liable to be counted towards qualifying service for the purpose of applicability of CCS Pension Rules 1972, and it concluded that the initial appointment of the petitioner was for short period or for a limited purpose. The Allahabad High Court has asked the apex Arya Samaj body to issue and introspect guidelines to abolish the solemnization of child marriages. The single judge bench of Justice Saurabh Shamesiri passed the order in view of people misleading Arya Samaj with the forged and incorrect declarations that both bride and groom are major and obtaining marriage certificates after solemnization of same in the ceremonies. The court pointed out that it has been taken note that the couples are tricking the Arya Samaj into solemnizing child marriages, and the same not only amounts to committing an illegality but is against the teaching of their guru as well. It amounts to betraying the trust of Swami Dayanand imposed on the members of Samaj, it added. The court opined that it is high time when Arya Samaj has to do introspection so that they may not be subjected to fraud, and they have to make stringent rules and procedure to verify the credentials of prospective brides and grooms, especially when they are on run from their respective families and they are approached through touts who are prevailing in Allahabad as they are promising couples on run, and they will get protection from the court. If responsible members does not take cognizance of this menace, a day will come sooner or later that Arya Samaj Mandir will become a place for solemnizing illegal marriages and their prestige will be in doom, the court remarked. Moving on to miscellaneous news. A special CBI court in Mumbai gave its verdict in connection with the death of actor Jia Khan. Actor Suraj Pancholi, accused of abating Jia Khan's suicide, was acquitted after 10 years on grounds of lack of evidence. Mumbai police had booked Suraj Pancholi under Section 306 IPC. In the letter, she had allegedly spoken about her troubled relationship with Suraj and said that she was physically and mentally abused by him. The Supreme Court has released a draft list of 10,000 of its judgments from January 1, 2014 to March 31, 2023 with neutral citation. A neutral citation is a form of citation where the Supreme Court assigns a unique sequential number to each judgment as a permanent identification. It will facilitate ease of citing the judgments by providing a uniform and common citation mechanism. The purpose was to facilitate the exercise of crowdsourced checking, that is, obtaining ideas, opinions, and knowledge for this project in legal professionals and legal publishers. The list of cases and proposed mutual citation is being provided, which can be downloaded in PDF and or CSV format. The Special Committee of Bar Council of Delhi has finalized the Delhi Advocates Protection Bill 2023. The object of the bill is to provide adequate safety, security, and safeguard advocates from incidents of assaults, killings, intimidation, and threats which has been frequently happening in the past. The committee has also included the protection of privileged communication between advocates and clients, and to acknowledge the freedom of expression and association. The Act is applicable to the advocates covered under the Advocates Act 1961, and while defining the acts of violence, offenders, punishment, and to provide compensation, it also provides for an important aspect to provide police protection to the advocates in case of any threat in appropriate cases. Notably, Permanent Grievance Redressal Committee at the level of each district courts and High Court of Delhi has been constituted by the bill. The Delhi High Court has asked the Delhi Police and Bar Associations to jointly address the security concerns in the district courts in the national capital and suggest measures against the same. The revision bench of Chief Justice Satish Chandra Sharma and Justice Subramanya Prasad, taking note of the recent shooting in the Saket Court, where a debarred lawyer shot a woman in an alleged fraud dispute, directed the senior officials of the Delhi Police and members of the bar associations to convene a meeting within 2 weeks. The Supreme Court has ordered that all records of criminal trials and civil suits at district courts be digitized in a step aimed at bolstering technology adaptation in the judiciary to enhance efficiency, equity, and ease. A bench of Justice Krishna Murari and Justice Sanjay Karol underscored the increased role of technology in creating a more accessible, inexpensive, dispensable, and transparent judicial system, issuing judicial directives in addition to SOP issued by the E-Committee of the Supreme Court for the digital preservation of judicial records. The court ordered that the Registrar General of the High Court shall ensure that all cases of criminal trial as well as civil suits, the digitization of records must be undertaken promptly at all district courts, preferably within the prescribed for filing and appeal within the laws of procedure, 30 or 60 days. The Chhattisgarh government has moved Supreme Court against the provisions of the Prevention of Money Laundering Act after certain searches being conducted by the Enforcement Directorate in the state. An original suit under Article 131 of the Constitution of India, which provides that the Supreme Court with jurisdiction of interstate or central and state disputes, has been filed challenging the constitutional validity of Section 17, Search and Seizure, Section 50, Power of Authorities regarding summons, reduction of documents to give evidence, etc. Section 63, Punishment for false information or failure to give information, etc. And Section 71, Act to have an overriding effect of the Prevention of Money Laundering Act. It has been contended that the above are ultra-vires to the Constitution and provisions of Chapter 5, Arrest of Persons, Chapter 6, Process to compel appearances, Chapter 7, Process to compel the production of things, Chapter 12, Information to the police and power of to investigate, and Chapter 13, Jurisdiction of the criminal courts in inquiries and trials of the criminal procedure code are applicable to the family. In the end, we have international news. The United States Supreme Court has decided to temporarily block a lower court ruling that had placed significant restrictions on the abortion drug. The justices granted emergency request by the Justice Department and the pill manufacturer to halt a preliminary injunction issued by the federal judge in Texas. The judge's order would significantly limit the availability of the medication as litigation process in a challenge by the anti-abortion group. French President Emmanuel Macron has signed his controversial pension reform into law, defying 3 months of protests and pleas from unions not to implement the legislation. The alterations became law after the text was published overnight in France's official journal. This followed the approval by the Constitutional Council of the essence of the legislation, including the banner change of raising the retirement age from 62 to 64. Unions warned that they were calling for mass Labor Day protests on May 1, and sometimes violent demonstration erupted in the several cities overnight after the verdict was announced. The battle to implement the law turned into biggest domestic challenge for Macron's second mandate, as he faced a widespread popular opposition to the changes, but also sidelining personal popularity. The nine-member Constitutional Council ruled in favor of the key provisions of the reform, including raising the retirement age to 64 and extending the years of work required for a full pension, saying that the legislation was in accordance with French law. The European Union has agreed to establish treaty relationships with Ukraine in the framework of Hague Convention on the Recognition and Enforcement of Foreign Jurisdiction in Civil or Commercial Masters, so-called Judgments Convention. Concluded in 2019, this Hague Convention is an international treaty that commits contracting states to recognize and enforce judgments handed down in civil or commercial matters in other. A court in Singapore dismissed an application by a 46-year-old Indian origin cannabis trafficker to have his case reviewed a day before the death row convict was hanged. He was drawn support from British billionaire Richard Branson, who claimed that the conviction did not meet standards and the Singapore may be about to kill an innocent man. The Ministry of Home Affairs had responded to Branson's comment, saying it showed disrespect for Singapore's judges and criminal justice system. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box. And for weekly updates, like and subscribe to our channel.